got anything on him?
What's that?
You got anything on him?
I don't know. I just put him out.
Now for what's tipping the scales of justice in the Subway Chokehold matter. A jury acquitting Daniel Penny of criminally negligent homicide for the death of Jordan Neely. You might recall the more serious manslaughter charge was dismissed last week by the judge at the request of prosecutors. This after the jury deadlocked on the manslaughter count twice. This trial deeply divided many New Yorkers, as was evident in the courtroom, when there were bursts of both applause and anger as the verdict was read. Jordan Neely's father, Andre Zachary, spoke to the media after the not guilty verdict. ABC News caught the moment.
I just want to say, I miss my son. My son didn't have to go through this. I didn't have to go through this either. It hurts. Really, really hurts. What are we going to do, people? What's going to happen to us now? I had enough of this. The system is rigged.
Jordan Neely's family has filed a civil lawsuit against Daniel Penny, a wrongful death lawsuit. So we're wondering this morning, will the not guilty verdict in criminal court tip the scales of justice at all in the civil courtroom? Let's bring back in our attorney guests, Bob Bianchi and Melba Pearson, on the show this morning. Bob, let me begin with you, please. Your thoughts on whether or not that criminal verdict is going to affect things in the civil case.
The criminal verdict will have absolutely no significance whatsoever in the civil case. Think O.J. Simpson. You can be acquitted in a criminal case where the standard is proof beyond a reasonable doubt, as opposed to in a civil case where the standard is much lower by a preponderance of the evidence, and the laws are very, very different. Simple negligence or assault can be actionable under civil, where in criminal, what you have to prove is much more significant, and you have to prove it to 12 jurors. So the two really don't intersect with one another. The question is going to be whether or not a civil jury will look at this any differently than the criminal jury did after a lot of deliberation, review of the evidence, asking to have readback and testimony as to whether or not the actions of the victim, quote unquote, in this case were substantially justified the use of force by the defendant. But the two may be very different. You may have an O.J. scenario here. We'll have to wait and see.
Sure. I have a clip of New York City Mayor Eric Adams talking about the impact on the city. Let's take a look.
We can't sit back and mourn the loss of someone that is caught up in this system when we're not taking the action every day. But a jury of his peers heard the case, saw all the facts and all the evidence, and made a decision. And I joined D.A. Braggs in stating that I respect the process.
Yeah, and also want to make note of something. Many of you may have recognized him on the clips we've showed you. Attorney Dante Mills, a friend of Court TV Network, friend of the show Opening Statements, a great lawyer, is representing Jordan Neely's family. And so it was kind of hard to see him, but he was standing next to his dad in that last clip we showed. And so he's the one who's going to be bringing this case forward. Melba Pearson, tell me, when you see the civil cases, following along with the criminal cases, it's something that as a prosecutor, I'm sure you kind of pay attention to it, but it's not your job, not your function. Here, what do you think Dante does at this point in terms of how do you kind of regroup? Because we know he was certainly hoping to see a conviction here, and then things would be a lot easier in civil court, as you know. So would you kind of talk to us about sort of the trial preparation aspects and some of the things you think would be beneficial at this point?
Sure. So what I would think he would be doing is a thorough review of the entire transcript from the criminal case, because he's going to look to see if there were areas that the prosecutor could have tightened up on, could have presented the evidence differently. He'd be looking to see what specific questions the jury was asking or what certain portions they wanted read back, so that way he can plug any gaps as he starts to present the civil case, and just basically try to learn from the lessons of the criminal criminal case that did not go in their favor, to try and sort of shift the balance in order to make sure that there's a positive verdict in the civil case. Again, just like Bob said, this is preponderance of the evidence. It's a much lower standard than beyond a reasonable doubt. Basically, 51% is the threshold, as opposed to beyond a reasonable doubt, which is much, much higher, getting close to 90% if you want to think of it from that perspective. So it's it might be a little bit easier for him to convince a jury that Daniel Penny's actions were not appropriate. And again, pointing to the issues of the fact that people were saying, listen, you're killing him, he's not moving, all of that. I think all of those aspects can work in his favor in terms of saying excessive force was used beyond what was needed just to restrain him, that it crossed into the line of wrongful death. And
Melba, that's really, really helpful insight. Thank you for that. Bob, let me go back to you on what the prosecutors did after the second deadlock that was noted. For the court said to the judge, we move to dismiss these charges. The court didn't, or charge rather, the charge of manslaughter. The court did in fact dismiss that charge. So then they just considered the criminally negligent homicide charge. That's all that was left. I'm curious, and I know you were a homicide prosecutor for many years. I'm curious if you think there was an overcharging here. Should they have just charged the criminally negligent homicide from the outset?
Well, you asked the million-dollar question that prosecutors look at all the time. First off, prosecutors should not be overcharging as a tactical decision in order to try to work a case out. Now, I know that there's a school of thought out there that if you overcharge, then you give the jury the opportunity to say, well, I'm not gonna go guilty on the highest charge, I'm gonna go to the lower charge. But I don't think that that's the way prosecutors should operate, and certainly when I was a homicide prosecutor, I didn't operate that way. I charge based on what I believe the facts could prove beyond the reasonable doubt with respect to the actual charge itself, and I'll tell you why. Because when you're in front of a jury and you're a prosecutor, one of the most important things you can do, in addition to having your evidence presented correctly and proof beyond a reasonable doubt, is your credibility as an attorney.
Credibility.
And when you go in there with an overcharge, you're hurting yourself.
Bob, I got to jump in here because we're just about out of time, but you're right. Credibility is key. If you don't have that, what do you have in front of a jury? Melba, you know that. All of you at home, you know that. All of our wonderful courties, great law lesson today. We'll be right back after this.